we will start. Okay, so thank you for attending Virtual Inspiring Abilities Expo. My name is Amy and I am a FUSE board member. I'd like to just go over a few housekeeping items before we begin. The session is being recorded and will be accessible through the FUSE website. Please consider this when sharing or asking questions. I will also ask that you remain muted unless asking a question. I'll be monitoring the chat box, so feel free to ask questions there and I will let our speaker know as questions pop up. I'm excited to welcome you to this morning's session on understanding your child's educational rights in the age of COVID-19, presented by Catherine Michael. Catherine is licensed and practices through the states of Indiana, Texas, and Michigan. She represents students and families in a variety of education and personal injury matters. Her nearly 2-decade career in education has focused on ensuring that the needs of children in schools are met. Please help me welcome Catherine Michael.
Well, thank you for having me. I'm really excited to talk about this topic because I think it is one that is affecting every parent who has children with special needs. Frankly, it's affecting every parent in Indiana. But where we're going to start, and I know that a lot of you are listening to this and trying to get that basic information, is understanding that during this time of COVID, your child does have rights and you as a family have rights. So I want to talk about where those rights come from and how to utilize them and what you should be expecting to see, how to ask for it and get what you're looking for, and some terms that I think it's really important for you to know. First of all, if your child has special needs, they're qualified for special education. They'd be qualified under a state law that is known as Article 7. And Article 7 basically provides the tenets for special education in our state. It provides where your child should be placed in terms of a specialized instruction versus a classroom. It has terms in it that we'll go over, including least restrictive environment, FAPE, which stands for free appropriate public education. And we'll talk a little bit about eligibility and how that works. Article 7 comes from the Individuals with Disabilities Education Act. And that is the federal law that covers all students federally who qualify for special education services. Now, at this point, you're probably thinking, okay, so all of these laws, I just need help figuring out what my child should be getting. They've been all online this year. They're not getting services. I just cut to the chase. What can I do? Okay, so the first thing that's really important is these laws, these two laws, and I want you to look them up. Article 7 also has a navigating the course. I want everybody who's listening when we finish this to go to the Indiana Department of Education's website. You can simply put in a search engine, Indiana Department of Education and Article 7. And there are two guides that are going to pop up. One is Article 7 itself, and the second is their little guide to Article 7 called Navigating the Course. You can also find a copy of your procedural safeguards. All of these things are going to be important because everything I talk about in terms of COVID, you're going to need to know where we're getting that from and how you can use these laws to help you get those services. So it's really essential you do that. When we talk about some of the struggles that parents with children with special needs have had during COVID, a lot of it is lack of services. And that's where that wording that I used before, which is called the free appropriate public education, comes in. A free appropriate public education is not guaranteed to all children. If your child has a qualifying disability, and that can be ADHD, autism, other health impairment, which is something that really covers a wide variety. If they have a traumatic brain injury, multiple disabilities, if they have deafness, blindness, vision impairment, frankly, if they have asthma, diabetes, most of these, if they have an adverse impact on your child's education, give rise to your child's qualification. Once your child is qualified, the educational services they are provided must be appropriate and must be designed to meet your child's individual needs. And that's where these laws become very important during COVID, because most of the programming that we've seen starting last March, when schools were scrambling to keep up, was designed on a sort of one size fits all, right? And I think when we talk about schools during that time, we've got to see it with grace. right? Schools, this was something very, very new to all of us. I think, schools had contemplated natural disasters happening. They had contemplated if there were things such as bomb threats. I don't think, other than Hollywood movies, we had contemplated a virus sort of sweeping through our nation and the world and having children out of school for a full school year. And in some school districts, we're talking even longer because they've not gone back. So I think we look at a little bit of last March and April and May with some grace. But when I say grace, your child is still entitled to recoup those services. And that's where we go back to FAPE. And just because something occurs in a school that is outside of a school's control, or because something happens in your child's life that is outside of their control as well, I want you to think a situation where your child is getting chemotherapy, or a situation where they're going to have to be out of school. The school has to put in place services that are going to be appropriate for those specific needs. And schools operate in nicely. This is almost a space term. They operate in a vacuum. Schools have the ability to make a lot of changes and to specifically craft your child's education to that. So I'm going to give you some examples, and we'll talk about, after that, we'll talk about some ways to get this, even if you didn't get it in the past, and some legal rights you have to recoup all of this. So I'm going to give you some examples. If a child has dyslexia, when we look at a specific program when school is out, we're also looking at that child, if all the assignments are being given online, they need to be getting their instructional material and where they're reading at, rather than the grade level material. They need to be having that same, if they are already in accordance with their IEP, they're supposed to be meeting with a reading specialist. The school had an obligation to keep that up, or this, last summer or even this summer, to try and recoup some of those skills. Where we're seeing a lot of children struggling is with behaviors. And this is where we talk about children who have autism, children who had emotional disabilities. So schools were obligated during that time period as well to be providing social skills training, counseling, be checking in with the parent, providing parent training, counseling services, social work services. These are all related services that could have come into play for your child during this time period. The other thing that it's important to understand about Article 7 and IDEA is that they have in place what's called a stay put provision. And so for those of you who are sitting in front of your computers or listening to me on recording, a couple of things that I've already said that I want you to remember. When we finish, you're going to get your copy of Article 7. You're navigating the course. I also want you to write down some of these terms as we go. And one of them is a stay put provision. If an IEP is proposed that is new from the school, okay, you have 10 days to challenge that IEP. And that's when you receive the copy. I tell parents if they're going to challenge it, you can do so through asking for a due process or mediation. If a school doesn't propose a new IEP, they are obligated to follow it. Now, for some schools, they're arguing this is a little unfair, but the fact is this is simply the law as I'm going to present it for all of you. So when March and April and May hit, and for those of you who had children with special needs, and all of a sudden your child wasn't receiving counseling, they weren't receiving behavioral services, they weren't receiving their resource room with that special education teacher, the law did not give them any sort of ability to say we're not following this IEP. Okay, so for those of you who are saying, well, but they just didn't do it, that's where we're going to talk about some ways to remedy that as we work through that. The school was obligated to follow your child's IEP, and that included in March, April, and May. So that's where we start to look at how many hours some of these children missed. Most kids who needed ESY did not get ESY last summer. Now, ESY is another term that if you don't know it, it's extended school year. And extended school year services are services that are anything that is beyond the regular school year. It can be over your Christmas break. It can be over spring break. It can be over the summer. And it is when we see a child who is at risk of regression, when we see a child who is right there, they're about to make some gains, And then we stop the school year and they're starting back where they were before, and we're just not making these leaps. That's where the school needs to offer those services. For children who have a lot of behavioral issues, extended school year services can become extremely important to keep and maintain that behavior. Most schools in Indiana don't offer a lot of summer school programming, unfortunately. Okay. And that's where, and I think probably most of you who look at your children's IEPs, the school meets and they say, we don't think ESY is needed. That is something frequent. And most of the time, unfortunately, it is needed because having that long off of school for a child who has behavioral issues or some pretty significant cognitive or academic issues, they really do need those continual reinforcements. So that's what we're looking at when we're hearing from parents about some of what happened March, April, May, and then we see the summer. Now, for those of you who have schools that didn't open through the fall, you're still looking at the same problems you were having early on. Most parents were experiencing issues with their child is trying to get on a computer, they can't. The material is above their head. They're not getting the one-to-one interaction. They're not getting any related services. I've talked to parents whose children only started getting speech therapy again a couple months ago. They haven't received any OT therapy at all or PT. And that's where we can say, okay, the law's been violated, right? Whether it was knowingly purposeful, the law doesn't care. Whether or not, if your child had an IEP that had these requirements in it, now is where we talk about how to get it fixed. And there are going to be a variety of ways to get it fixed. Now, before I go through that, I want to talk about this in general terms as well. Many parents have IEPs that they don't think are appropriate for their child, but they're not sure what to do. And that has been coming to a real head during COVID because a parent is now working with their child and seeing that they can't read, they can't do basic math, and they're really struggling. I have a number of clients that they thought their child all along, this was simply ADHD. Okay. And this is, I would say, the biggest thing that I've seen during COVID is parents whose children had ADHD, and they're now working with them and seeing, my child's really struggling with reading and they're really struggling with basic math. I think there's something more to this. So we're seeing that parents actually this year, went out and got independent evaluations. They got evaluations, whether it was through their medical insurance, Medicaid, whether they requested them from the school, and we'll talk about that as well. And so that's another word I want you to write down or remember is an independent educational evaluation. And they're discovering that their child has a specific learning disability, a listening comprehension disability, dysgraphia, dyslexia, processing speed issues. And so that's something that when parents were sort of forced to be working with their children all day long, every day, they started to make this understanding. This is not simply their child not doing their homework, which a lot of parents hear. Johnny doesn't try hard enough. Tiffany is just a talker in class. That's why she's not doing well. And then we'll see eligibility, but we see it under OHI for ADHD. And really, we have much more of a problem. So that's a lot of what I have seen during COVID. And so we're going to talk about some remedies, and we're going to talk about how to get those remedies, and then what you can do on a proactive basis moving forward. So back to that stay put. When you disagree with a child's IEP, just in general, many parents feel when they sign their name to it, because that's the other thing, if your school changed your child's IEP during COVID, a lot of parents just signed it. When you sign an IEP, you are not signing it like it's a legal contract and you agree with it. When a school develops an IEP, it is their offer of faith. When a parent accepts it, they are simply agreeing for those services to go into place. You can sign an initial IEP or any IEP, services go into place, and a parent can then file what's called an educational due process complaint. They can ask for a mediation, or they can even file a complaint on procedural problems that are occurring with the IEP. So with those initial IEPs, if a school just developed them, parents always have to sign it just to avail themselves of the services. So if during all of this, your child wasn't receiving the services, the first thing you can do is called a complaint. And that complaint is something that is filed with the Indiana Department of Education, and that's something you can search. Parents can file that on their own. It's a procedural complaint. And what you're doing in that complaint is telling the Indiana Department of Education that, let's say your child had been not receiving speech services for March, April, May, no services for the summer. Fall started, they still weren't receiving speech services. You can actually ask that the Department of Education have a investigator investigate that, and just then order the school to provide those speech services. If your child wasn't receiving services from the reading specialist, you can file that complaint. So any deviations from your child's IEP, you're just going to go through, take that IEP, highlight it up, and start saying, these are the services that weren't provided. The filing a complaint with the Department of Education is very, very simple. And they are there to sort of guide you through that process. Obviously, the first thing that we would hope is that you've gone to your school and said, hey, I have a problem. You're not providing these things. I'd like if you provided them. I'm asking you to do this. A lot of parents have done that, at least that I hear. A lot of parents have done that, and then they've expressed frustration that it's just not happening, right? Or a school will say, sorry, yeah, I know we didn't do the 50 hours, but we think that we can catch your child up in 5. Okay. And that's what a lot of parents are hearing, and what a lot of parents get very frustrated about. So that's where you can go to the Indiana Department of Education and simply file this, have a complaint investigator investigate. They will work with the school, have the school file a response, and then they will issue what they call a corrective action. Okay. You don't need an attorney for this. This is just a very simple 1-page document that you can fill out. You can call, you can talk to that investigator. And so for those of you whose children didn't receive services during that time, that's something important to do. Then we can get into the more complicated cases, and those involve LRE, which is the least restrictive environment, and violations of FAPE. And that's where we start to look at what exactly is a child entitled to in general, right? So all of you who, I'm sure some of you have children in a general education environment or under 504s. And a lot of this is going to be specific to children who are qualified under Article 7 and IDEA. So when a child becomes eligible for special education, not only are you entitled to a specialized educational services, you're entitled to that child being educated in the least restrictive environment for them, which means a classroom. The general education classroom is where it starts. So we start off with the general education classroom, then we go to a general education classroom with aids and supports, then we go to a general education classroom with pullouts, then we go to a general education room with even more pullouts, some resource, specialized instruction. Then we go to where we're looking at a special education placement, like a resource room, an emotional disabilities classroom. Then we're looking at therapeutic day placements. Then we're looking at residential placements. The most restrictive environment on the spectrum and under the law, in case law and in the statutory law, is a homebound setting. That's actually considered more restrictive under the law than placing your child in a residential, believe it or not, or a therapeutic day placement. Most parents don't realize that. They don't realize that their child would have been entitled to a therapeutic day placement if a school couldn't manage them versus getting placed on homebound. The other thing that we have there is all of the related services that children are entitled to. And I think during COVID, we've been seeing increased need for social work services, counseling services, recreational PE type of services, related services. And when you review your copy of Article 7, you'll see there's quite a few. And that's where we start to look, and this year has actually been one for parents to take a really close look at what their children are getting, is what services are provided under Article 7 versus what that child is receiving. In my practice, I represent parents of children with special needs against school systems, and these are not damaged related cases. So when a parent has a concern that their child is not getting FAPE, and we'll talk more about what that means, and this is especially, we're seeing it really heightened during COVID, they can file an administrative complaint with the Indiana Department of Education, and it's not through state or federal court, it's simply an administrative complaint asking the Department of Education to appoint what we call an independent hearing officer. That independent hearing officer is supposed to look at all of the data, which would include the child's needs, their evaluations, their grade reports, disciplinary reports, speech language evaluations, all of this data, and then take a look at what the school is offering, and then they can remedy it, change it, or say it provides appropriate services. So what I've seen sort of happening during COVID is more parents who have children with really fairly profound disabilities are starting to realize that the IEP they had with only one goal or two goals really isn't meeting their child's needs. And often these IEPs were created like a parent comes in, and all of you who go through IEP conferences, including our moderator who has to go through quite a few of these, you come in, most parents though feel a little overwhelmed, and I have been there, right? You get there and it's a bunch of teachers, staff, and they basically go through often what parents will hear. It can go a couple different directions. One is your child is doing really good. I think, the biggest thing that we need to tackle is organization, and you'll get one goal. The other extreme that we see are with children who have behavioral issues. The parent will get to hear all about the child's behaviors, and then the IEP will have one goal, okay? Parents are starting to realize, and I think part of it is that they've had more time with their child, again, that their child has a multitude of issues. This isn't just an organizational issue. Their child is really struggling socially. Their child is struggling emotionally. Their child is struggling academically. Their child is struggling with organization. They're at home and they can't figure out where they put their homework. So that's again where I'm seeing parents starting to recognize there's a bigger problem here. And again, we're seeing more of it this year than we have in the past. And when you have a bigger problem, the first way to try and go about it, I really like to see parents go and get what's called an independent educational evaluation, because it's somebody who is outside of the school and then outside of you who can do a full-scale psychoeducational evaluation on your child at no cost to you and let you know, look, I think the school is doing a great job, or your child does indeed have a lot of needs, and here are my suggestions. Okay. The way a parent requests an independent educational evaluation, and this is a good thing to do, especially after COVID, if your school's not going to do another evaluation, is you're going to send a letter to the school letting them know that you don't believe that the school's evaluation is accurate, that you disagree with it, and that you want something that is more comprehensive. Now, if you love your school's evaluation and you think it's hitting the nail on the head, but the school's not providing services, you don't need to do that, okay? But if you're looking at that school's evaluation and it says like Tammy has ADHD, and you're looking and there's no IQ score, Tammy's really been struggling with reading, you've gone to the school repeatedly about these issues and you're not seeing changes, this can be an excellent way of actually understanding your child's needs. And it's available to you at no cost. Now, if the school thinks they've done a great evaluation and they think that Tammy does indeed just have ADHD, that they covered all their bases, there are cases where they can file a due process against the parent to contend that their evaluation is the correct one. If they do that, as a parent, you can just, I would tell parents, well, let them do a new one first if they really want to do that. And then just see where you want to go. Because if you withdraw that request, or you go through your insurance, you go through private pay, or you go through Medicaid, you don't have to ask the school for it. And they still have to consider all of those results. Okay. But if you you shouldn't have to use your insurance if the school's done a really half-hearted evaluation, quite honestly. And I do think that it's sometimes a way to bring the parties together when you get somebody from the outside who's going to say, look, I took a look at this kiddo and here are the issues we need to address. But as a whole, when we start to look at this, When a parent really is looking at what their child received during COVID and saying, it was absolutely inadequate, my child's IEP is absolutely inadequate, I feel like I've been banging my head against the wall for, 18 months now. What do I do? That's where they can pursue an educational due process. And an educational due process, again, is not something to be scared of. I mean, it's not pleasant. I mean, that's for sure. And I think our moderator can tell you, if you're a teacher and you get one of these, right? It's this, fear response. But they are opportunities for a school to recognize that, hey, we've got a problem and let's get in early and solve it. Right. And I think parents want to get in early and solve it. Most parents, by the time they get to me, have tried to solve it, right? Attorneys are not everybody's best friend, right? It is intimidating and terrifying. I mean, I don't like to call one, for something. So, but by the time a parent gets to me, they're usually like, I have tried everything. Okay. And even, my advocate tried everything. And sometimes I will see years lost. The number of students I get, and this is sort of a wake up call for everyone who have specific learning disabilities, who are in their last 2 years of high school and haven't really been provided appropriate services, the numbers are pretty shocking. And so that's where I say to parents, if you really don't feel your child is being served, don't keep delaying. If you've asked and asked and asked, these things aren't that difficult. You're not asking the school for $1 million. You're just asking the Department of Education to appoint somebody to make these decisions if the school can't. Most hearings are 2 to 5 days. Some are just 3. Some can be longer if they're really complex cases, but they shouldn't be. I've certainly been arguing to simplify these things to the maximum extent possible, because again, under IDEA, they were supposed to be things that parents could even do on their own. But if you've had a situation during COVID where you're really at a loss as to how to fix this, and your child is at this point at a risk for an extreme level of regression or lack of services, it's certainly a route to go. And so, I want to encourage you to do that. The other thing that I want to talk about, and that I sort of gave you a little bit of information on, is LRA. So there are times where LRA didn't apply during COVID. So in March, April, and May, even if your child could not learn on computer, schools are going to be given a little bit of grace, even though they were not absolved of having to follow their legal responsibility. So what should have happened when we talk about children who are really profoundly impacted, let's say a child, I'm going to give you an example, a child with autism with pretty enormous behaviors, who now is in a situation where their behaviors are deteriorating, they're losing communication skills. March has happened, April has happened. That's where the schools should have been looking into ABA-based centers. And some of them were. And so in Indiana, I saw schools, and especially some of the virtual schools, that actually stepped up and put and placed students in ABA centers because they were open, and in therapeutic day placements because some of them were open. Now you had to go through the quarantine, but they realized that if these kids don't get services for sometimes a 6-month period, that they're going to lose such a great deal of services that it becomes irreparable. In those cases, that's where, again, that LRA is, that child's least restrictive environment is not on that computer at home. That would be that therapeutic day placement. The thing along that therapeutic day placement realm too is we've also seen children who had extreme behaviors, some of which is resulting from significant mental illness, like a schizoaffective disorder, and things along those lines. Those kids who could not be at home, school districts still had an obligation to place them in a residential placement during that time. They were not absolved of having to do these residential placements. And I've seen a lot of kids over the past year who have deteriorated to a state that they're a danger to themselves, they're a danger to others. They cannot be educated in home-based placements, and that school district would have the obligation to do that. That is on the continuum of services and placements that schools are responsible for. And I know we're getting some questions, so I'm happy to answer them as we go, or I can do little breaks along the way too.
We had one that's asked, when do you recommend seeking mediation?
I recommend seeking mediation. Well, a couple of different ways I'm going to approach this question. I actually like to do mediation once I've filed for a due process. This is going to be different than the answer I'm going to give if you're just a parent on your own. The reason why is I like the timeline, and I like the fact that if I'm seeking mediation, there's already a dispute, and sometimes writing a due process letter, getting a hearing officer already involved can get the case resolved really quickly, right? The school all of a sudden has a lot of impetus to get this thing done. And so that is when, in my practice, I don't schedule the mediations outside of due process because it's just not as effective. It often takes me a few weeks to schedule the mediation. Sometimes we'll do the mediation, then it's a due process. My goal is how do I get this resolved for the parent as quickly as humanly possible? Because again, by the time they get to me, they are like, I am done, okay? Now, for parents out there on their own who are, thinking along the lines of, things aren't going well, but I think that I just need to mediate this. I think you can do that, anytime, right? You've come from an IEP meeting, you're like, we're just not making progress here. I don't know if it's the communication, but I think somebody needs to facilitate it out. So if I think that it's a issue regarding communication, if I think that, for instance, and this is for parents, the school's just not hearing you, and you think that having somebody neutral get involved is going to help facilitate that conversation, that's the time to do it. If the issue is far more profound, right? Again, if we have an issue of a child who is in 10th grade, you're positive they have dyslexia, you've had to get them tested on your own, you've been paying for Linda Learning Center or Linda Mood Bell out of your pocket for years. Sometimes at that point, let's just sort of cut to the chase and get somebody already lined up to figure out how much compensatory education your child needs, versus doing mediation. But mediation can be terrific if it's a failure to communicate fully, and you're willing to make some compromises. But here are my big tips to be careful of in mediation. I have had parents go to mediation on one thing and sign away all of their rights, including tort claims. So I'm going to give you one example, and this did happen in real life. Parent went to a mediation over the length of their child's day. The school had the child going to school from 10 to 12 every day. And before that, he had been on homebound. And this was before COVID. Okay. That parent did not know that their child was entitled to a full school day, right? They hadn't read Article 7. They had no idea. They went to a mediation and they agreed that their child would get 4 hours a day. And they signed a waiver of all claims, okay? We later found out after they came to me, the child had not received adequate services for years, no speech therapy, OT, child with multiple disabilities. It came to light that one of the teachers had actually, and they got reported to DCS, but had been engaged in some abuse of kids in that classroom. We got information. A parent had signed a complete waiver, all to get 4 hours a day, which again, they were basically getting less than they were entitled to by law. The other concern I have sometimes with mediation is about compromise, right? A lot of life is about compromise. But if your child needs speech therapy and they're trading minutes of OT for speech, or you're trading away a reading specialist to get extended school year services, you're actually trading away what you're already entitled to. So, those can be the red flags in mediation, because that mediator, they are not there to teach you the law. They are not there to create a campaign for you. They are simply there to negotiate out a compromise between the parties. So those are my feelings on mediation. Again, I use it in the vast majority of my due process cases, and I think it's extraordinarily helpful there. I use it a ton in Texas because all of our hearing officers there are mediators. So they get to, you get to see them outside of that. They know the law fairly well. The vast majority of my cases settle in mediation, about 99% of them, either mediation, resolution sessions, or just in letters. We go to hearings on less than 1%, but that's something to keep in mind. That's it. And one little last thing there, if this is something where you have a good relationship with the school, but you just need to smooth a couple things over, mediation is a fine option, but just be wary of using it when the issues are really big. Any other questions yet? Okay, so I will just continue on. So when we talk about dispute resolution, and I use the term compensatory education, what compensatory education means is the services that your child should have received but didn't. So I'm going to give you an example pre-COVID and then an example post-COVID. The example post-COVID first is what I was describing earlier. March, April, May, your child doesn't get speech therapy. They don't get one-to-one reading services. You're entitled to what's called compensatory education. And the Department of Education can actually have that investigator create a corrective action that provides that to your child. They will go through, they will look at what your child missed, they will look at how to make it up, they will spread those hours out, and they can simply issue that corrective action. That is not complicated. When we talk about pre-COVID types of things, or when it's a really big issue, that's, for instance, your child should have been entitled to special education. I'll use that reading example. A child who's a dyslexic, they have not passed I-STEP, they are in 10th or 11th grade, really, really struggling. And you come to me, your child's eligible for special education and the school has not made that. A hearing officer, now they can only look back 2 years, unfortunately enough. A hearing officer can do a couple of things. One, they can make an order of a private program to try and recoup exactly where your child is at. Let's say they are at a 3rd grade reading level. We know they're going to need something extraordinarily intense to get them up to where they should be. And so they can award a private program. They could award something like Linda Mood Bell Academy, some of the dyslexia summer camps. If your school has programming, they can actually put in place saying, look, this child clearly, we're hearing testimony that they need multiple hours a day of reading intervention at this point to catch up. Your school can actually put that in place. So hearing officers will often look at what can this school district actually do before they order a private placement. But that's where they're really going to consider what can they do and do I trust them to do it? I have had hearing officers say it's pretty apparent that they can't do it, because if they could do it, they would have. And so in those cases, it'll be a situation where they will award those private placements. Others will actually say, I'm going to put in place this type of program, and in addition to this child, let's say this is a child who needs to stay in school longer than their 22nd birthday, they'll say, I'm going to add an extra year onto their education. So if they want to stay in the school system, you're going to have to go beyond their 22nd birthday. I'm awarding a full extra year of school. Now, we often don't see that in the reading cases. We see that more in children with cognitive disabilities who are denied some of like those vocational services and things beyond that. But hearing officers have a wide ability to award those types of things. And so when we talk about compensatory education, there's a lot of ways to make it up, and it depends on what it is. I'm going to give an example of children who needed a communication device and never learned to communicate. Some school districts, I'll see it all over the place. I'll see a child who at one school was using the picture exchange communication system known as PECS or PICS. And then they'll move to another one and they'll give them an iPad, and they'll move to another one and they'll try sign language. And we have a child who has not learned to communicate at all because nothing is being used with consistency and fidelity. A hearing officer will sometimes ask to hear from experts, what do we do now? This is a child who should have been able to learn how to communicate. How do we fix this? And that again becomes compensatory educational services. So when you hear those terms, that's what I'm talking about, is how do we fix it? Now, a school can offer you this on their own. They do not need a hearing officer to order it. And I have plenty of schools In good school districts, you'll get a new special ed director in, they'll come to a meeting and they'll be looking at something and they'll say, look, we dropped the ball. Your child didn't get X, Y, and Z, and we want to fix this. And they'll say, we're going to do 75 hours of compensatory education. We're going to go ahead and start this summer. Here are some additional options. We'll do the ESY, plus we'll put your child in summer school with the one-on-one aid. I do see a lot of schools that with good directors step right up and do it. So again, this is not something you have to have a hearing officer do. It's something you can ask for.
We had another question. It says, is it ever appropriate for parents to seek parent caregiver training or paraprofessional training if a child is demonstrating behaviors? Sometimes behaviors are simply because this child's needs are misunderstood. The child is being underestimated, but does not have enough supports. The child is not being given access to meaningful mode of communication beyond speech, etc.
So absolutely. So I'm going to break that down into three different answers. One is on what the school is supposed to do in terms of behavior, and we'll talk about the FBA and the BEP. And the next is the duty to have parent training, and that can include caregivers, because we want behavior plans to be, I'm using those terms, fidelity and consistency. We want it to be employed across environments. That becomes absolutely essential. So the first thing is, when a child has behaviors, a school is supposed to do what's called a functional behavior analysis. And that basically, that analysis of behavior or assessment, functional behavior assessment, sorry. You can tell, I didn't quite have enough coffee and it's almost 2, but basically what we talk about with that type of assessment is a real systematic approach to looking at those behaviors. When do they occur? How do they occur? How frequently do they occur? Do they occur with certain tasks? Do they occur at a certain type of day? What was the antecedent to the behavior? How loud is that room? What was the behavior exactly? And what actually occurred, which was the natural consequence? So I'm going to give you an example. A child is acting up and throwing fits, destroys a classroom. They call the parent, the child goes home. Okay. The cause may be all of a sudden the child is getting some really difficult work. They have learned that destroying the classroom gets them to go home, right? We actually will then see that behavior skyrocket, right? And then we sometimes will see a school telling a parent, we think your child needs to be on homebound, or how do we handle early pickups, or let's have a shortened school day, right? And then we see the behavior get worse over time, naturally, because that's what we would see if we're doing this analysis. And as I said before, every child should be having a full school day anyway. That is guaranteed by law. So unless your child needs a shortened day, again, think in terms of a child with a mitochondrial disorder, or who's getting chemotherapy, or who has, some reason that they physically cannot do it. Okay. So that FBA will look at all of those things. And it would look at, for instance, I see behavior plans all the time that says, Sammy bites, kicks, hits, and elopes. Okay, that tells me nothing. Okay, I don't know if he bit somebody 2 weeks ago, or if he's like a regular little biter, right? Am I going to see him and he's going to bite 3 times? So we really need an FBA that is extraordinarily comprehensive. So that is number 1. And because if you don't really understand when or why things are happening, then you're not going to be able to fix it. The next thing we need to understand is what behaviors here are going to be organic and what are going to be changeable. And the reason I say organic is I will see behavior plans that are trying to address a behavior that a child cannot help, a sensory-like behavior. We are not going to be able to stop certain types of behavior. For instance, a stereotypic type of behavior, a situation where a child, has obsessive compulsive disorder, right? If there was a really great technique that worked for that, every psychiatrist in America would basically have signed up for it, and Prozac wouldn't be doing such good business still, even in a generic form, okay? So we need to distinguish between behaviors that are absolutely related to that child's disability that we're not really going to target, and behaviors that are being exhibited that are changeable. Biting is changeable. Kicking is changeable, but I want to tell you, sometimes not always. I have had clients who were really cognitively impaired, and when something's painful and they can't lift their arms, they can't lift their legs, they bite, right? That is something that is going to take a while to change, because blinking their eyes or trying to move their nose is not getting the message across, right? And so there are things that we have to have that concept of understanding. But let's say in general, for most children, elopement, biting, kicking, hitting, bullying, throwing away papers, destruction, those type of behaviors are changeable. And then we're looking at, why is the child doing these behaviors? Often schools will say it's avoidance, okay? Or they'll say it's for control, or it's for attention, okay? Sometimes it's just because the child wants to go home. Sometimes it's because the work is just way too hard. It's not task avoidance. They actually cannot do the work. Other times it's truly because they are exhausted, right? They are on complete sensory overload. They're not trying to get attention. They're melting down, okay? So we really need to truly understand why the behavior is happening, because saying a child is trying to get attention when we need to be giving them breaks every 20 minutes and giving them sort of outlets, giving them quiet times, some children even giving them a nap in the afternoon, we need to be very careful at how we structure what we're going to do for these behaviors. Then we're looking for replacement behaviors, okay? And that is, if I start to kick and throw a fit because the task is too hard, what type of replacement behavior can we use? And so that's where I say we always want to have children working at their instructional level as much as we can. And then we present some grade level things, we mix it up so that we can sort of downplay that task avoidance so they feel like there's success, right? All of us don't want something that is so difficult we feel like we're never winning, right? So you want to start to build a different type of program. And that has got to be really spelled out with specificity. And I think, any teacher can tell you, if it's not spelled out with specificity, it's going to be really hard to implement, because Mrs. Moss down the hall may be doing it totally different than Miss Patterson, who is doing it different than the one-on-one aide who has had the flu for the last 3 days. And then there's the replacement aide, who's Miss Jennifer, who has not read this child's IEP and doesn't know any of the details, okay? So that's then, we have to have a good FBA, we have to have a good BIP, and then we have to have everybody trained on it. And when I say everybody, this is where parent training is a part of Article 7, and it's a part of IDEA. When we talk about parent training, it's not that the parent doesn't, know anything about their child. It's, what are we putting in place, and how do we make sure that the parents, the caregivers, the one-to-one aide, and every staff member working directly with that child is on the same page, or else we're not going to change anything. And I can always tell we have a disconnect in schools when I have one teacher reporting to me that Johnny is an angel in our class, right? He's cute, he's doing the work. And then the teacher down the hall is like, he's a hellion. He is not paying attention. He is not working hard. He is losing his papers. He's throwing fits, because they're using very different techniques. One teacher may be doing a lot of positive reinforcement. He loves her class, right? And the teacher down the hall may be like, sorry, you know what? This doesn't cut it. And so then you'll start to see those behaviors really escalate in one class versus the other. But training is a required component.
We had a follow-up comment and then another question. It says, as a follow-up, research is showing that nearly 2/3 of all autistic students are experiencing movement differences that can impact speech and purposeful movement. When this isn't understood, some of the child's responses are misinterpreted as behavior or lack of cognition. This doesn't improve with behavior management unless the child's will is broken and they give up, but their academic education stalls at that point. Instead, if the child can get sensory and motor supports, they can regulate and participate and respond to curriculum. The question says, how do we help schools adopt newer research when it is available and address things based on the neurologic needs of the child / a need for supports instead of behavioral assumption?
That is such a terrific question, because I really do see that many of our schools are very behind the times in what they see work. They're also really behind the times in training staff are providing staff the resources to get this training. I would say Indiana, to me, is certainly behind some of the other states in terms of giving staff access to that. I think the number one thing parents can do is go to a case conference and look at it as you educating the school. Bring materials, hand them to teachers. If there are free online seminars on autism that you are aware of that are providing some of this information, send them links. I mean, you shouldn't have to do that, right? I mean, schools in theory should be doing this, but the fact of the matter is they don't, right? And most teachers, when we provide them this information, are like, thank you. I have many friends who are teachers who, will tell me, okay, this was years ago now, because those who are my old friends, they wouldn't know which children in their class had IEPs. If a child had autism, they knew they had autism and they knew they had 2 goals, but they weren't doing much except for when they had to do the progress reporting. It was really hard for them, and they weren't being provided any of the supports or the training as to, for instance, some of the movements, sensory issues. When we even talk about brushing, this is the reason I bring up brushing is I had a teacher friend call me 2 weeks ago saying, what in the world is that? The OT said I should be doing it in the classroom. And, I knew I had like 3 kids that the indirect consultation that said I should be doing brushing. I have no clue what this is, and I don't know who to ask. And so, we went through describing how that works. And I thought, this poor teacher, she's having to do the sensory and stuff in her classroom. The OT is not coming in. Now she's supposed to be consulting with the speech therapist and doing indirect speech therapy with like 10 kids in her class. And mostly, we don't have IEPs in a really systematic way. So I'm going to describe one school district that I saw that had a really beautiful system. They had IEPs color coded. So a teacher could immediately come in and they would have, for instance, multiple disabilities. I'm going to use example colors because I can't remember exactly what they had. They would have those in pink. Autism, they would have in blue, ADHD in green, so that you could immediately get a feel for your classroom, right? Then they also did individual plans for all the children in the classroom who did not have special needs. So a teacher could lay everything out and get a fairly good assessment of who was in her classroom or who was in his classroom. They could immediately access their scores from iStep. They could look at their NWEA scores. So they could easily break kids into reading groups. And this was all in print. So a teacher didn't have to be trying to flip onto IEP, find something there. And for most teachers, for those teachers who are watching, you absolutely have access to a child's IEP. Any child in your class, that aide should have access to that child's IEP. Any staff member working with that child should have access to their IEP. Okay, this is not something to where there are privacy concerns or FERPA stops you from getting access. And so that's one rumor I would really like to dispel. The other thing that I've seen schools do is actually have a weekly meeting to go over, in that teacher's classroom, here's the behavior plan. What are you seeing work? And they have all the teachers do a meeting and they go through, they check off systems, they create like cheat sheets for them, they create checklists. And those school districts are usually extraordinarily successful because they've gotten a lot of buy-in from teachers. Parents see the checklist, parents see all the details, and everybody's on the same page. And it creates a lot more strength and a lot more unity. Right. Any other questions? As I know we're sort of coming to the end. The biggest thing that I have as a takeaway for parents is that do not forget that you have rights. School systems also have very, very little enforcement outside of parents. Parents are the equivalent of private attorney generals in respect to enforcement of their child's rights. And most people don't know what that means, but when Congress and the Senate were passing IDEA originally, the idea was that, no pun intended, but the thought was that it would be impossible to patrol this. One child with autism may need something completely different than another child with autism. One child with dyslexia may need Lindemood Bell, another may need Orton Gillingham. One child with ADHD may just need preferential seating, another may need an entire IEP to teach them how to get organized. And so the law was made to be enforced solely by parents. The Department of Education isn't looking at your child's IEPs, right? They're just asking, hey, did they meet yearly? You are the only enforcer of what is a free, appropriate public education. You're it. So schools have very little enforcement. And the number of even due process or complaints that get filed against schools in most states is literally like 1/1000th of a percent of parents who have children with special needs. So of course, we're going to see, like with any sort of low level of enforcement, schools are going to cut corners. And they tend to cut corners in terms of teacher training, staff ratios, whether a child needs a one-on-one aid, bringing in some of those new programs and teacher supports. The way that we get that changed is for parents to be very vocal about what their child needs, why they need it, what they believe they're entitled to, and just to be as I guess involved as possible in that process, and understanding that just what a school offers is not a one size fits all. And you have to go into this knowing that you are the enforcer and not be scared of it. Again, everybody is working for a common goal, but you are the only one who is going to truly know your child the best and be able to ask for things. I mean, I see teachers all the time who have actually sent parents to me because they can't get an aid for that child or they can't get additional services. So your child's teacher is likely concerned as well, but sometimes they're not going to tell you. But it's important that you realize you have these rights and that you use them. Right. I know I have a couple more minutes. Any more questions?
Says parents really need to be given that information. So many are concerned but highly intimidated.
Yeah. And I guess that's something too. Don't be intimidated. I mean, while schools get a little frazzled when they get a due process, again, you're not asking them for $1 million. This isn't a personal injury lawsuit. It's not tobacco litigation. I mean, for goodness sakes, it's saying my child needs a reading program. And most of the time, if a parent files a due process, or files a complaint, I see a lot of parents that are afraid to just file a complaint saying, my child hasn't gotten the speech therapy. You have to take a step back and say, well, you can either pay for it yourself or you can ask them to provide. I mean, this sounds a little mean, but it's true. Schools are the government entities that are supposed to be providing these services. Do not be intimidated about asking them for it. Don't be intimidated about asking the Department of Education to step in and say, yeah, I mean, this child needs the speech therapy, because being an advocate for your child is not going to be easy, right? If it was easy, we wouldn't even have to have these conferences, right? I mean, everything would be working out really well, and we'd just be talking about, something else over the weekend. Maybe, the problems with medical insurance, which I know that a lot of parents with special needs have as well. But it is just important for you not to be scared of the process, to embrace it, and to know that being an advocate of anything in life is going to have some difficulty. But the good thing is your child is advancing year to year, so you probably won't have the same teacher if that was the issue. But don't be afraid. And I mean, there are lots of people out there that will help. Don't be afraid of the costs either. Most special education attorneys, we're doing this because it's a labor of love. They have, most attorneys have sliding scales. They take good cases. There's a fee shifting statute, an idea, which actually allows parents to seek their attorney's fees from a school. Many schools just want to nip it in the bud and try and solve these things early. And so I think is my biggest message is, if things have happened during COVID that weren't so great, or you've come to different realizations and there are things that you need to challenge, don't be afraid to do so. It may be somewhat easier than you think. And then for those of you who had great experiences during this process, or during COVID, kudos to your school. When I see that, it renews my faith in our education system. And I've seen some really great things over the past year as well.
Are there any last questions before we wrap up today? Okay, well, thank you so much, Catherine, for your great presentation. I want to encourage everybody that is attending to make sure that you still check out the exhibitors and community tabs within the app. And if nobody has anything else today, we'll go ahead and end today's session.
All right. Well, thank you so much. And I hope to see you again soon.
Thank you.